WATE 6 on your side legal analyst Greg Isaacs is here as we dig into the verdict in a second trial over the killing of Ahmaud Arbery. Greg, as always, thank you for being here.
Lori, it's good to be here.
So we're talking about this second trial. The first one in state court. All three were convicted. We're talking about the defendants. Explain what's different this second time around for those same three.
Lori, people want to know how you can have a murder trial involving the same three people in state court and the same people, same facts in federal court.
Yeah, what's the difference?
Under the doctrine of separate sovereigns, you can be prosecuted in state court and federal court, different statutes, different judges, different juries, but a much different trial. This case involved violation of a federal statute that originated in the late 60s under Lyndon Johnson, interference with civil rights. Now, the homicide trial was a hard-fought murder case talking about whether the McMichaels were justified in using self-defense, whether Brian, who blocked Ahmaud Arbery in with his truck, was involved as a facilitator. This case, much different under the federal statute. This is a case about whether the unfortunate killing of Ahmaud Arbery was based on racial animus.
So what does it take to prove that?
To prove the requisite racial animus, this was a case that spanned 8 days, 20 witnesses, and instead of witnesses to a homicide, you saw witnesses that talked about Facebook postings, text messages that showed, I mean, Lori, racial bias, bigotry. We couldn't address them on this program. So what it was a mini trial to show the racism, the bigotry, the motivation for the conduct, and then to show that that interference with Ahmaud Arbery's civil rights to be free from that type of discrimination led to a kidnapping and led to an unfortunate homicide. But that jury heard things, Lori, that were really unspeakable as it related to their motivation as it related to racism.
Incredibly, incredibly disturbing. I wanted to ask you this. At one point there was a plea agreement. Why did this go to trial?
Wow, and that was kind of a landmark situation under 11C1C. That's an agreement where the defense and the prosecutors agree on a sentence. And what was at issue, it was a 30-year sentence, but really, in the grand scheme of things, was a nullity based on the state convictions, which were 2 life without paroles and 1 life with parole, which is 51 years. But it was preferred conditions of confinement. So the lawyers wanted their client to serve 30 years in a federal penal facility versus a state penal facility. Raised really interesting issues under the 8th Amendment, cruel and unusual punishment, on whether you can send someone to the place you think is better or more inhumane. But really what's interesting about this case, I think you're going to see the feds use these federal statutes that originated in the 60s here in 2021, and you're going to see this trend develop when there is a crime predicated upon racism.
2022, but that's okay.
I've lost it over COVID.
Oh my goodness. All right, Greg, thank you. A strong statement was sent here for sure.
Very strong statement.
All right, everybody, if you have a legal question, send it Greg's way. We'll see if he can clear it up for you. Just email AskIsaacs@WATE.com. And remember, we have Greg on for Ask Isaacs every Wednesday at 5:30 right here on WATE 6 on your side. Stay with us. We'll be right back.